Hello and welcome to this masterclass on non-executive directors. My name is Gibbon QC. I'm a barrister in Maitland Chambers and I specialise in litigation and advocacy in relation to company law, insolvency law and commercial matters generally. A non-executive director, I think in my experience, where people have come through the door and described themselves as such, is somebody who doesn't run the company day to day, may not be employed by the company, is perhaps there to give some form of strategic input, a wider commercial perspective, or indeed the wisdom of many years' experience that that individual has had in a particular industry. What may come as a surprise to many people, particularly those who have not advised in relation to company law in the past, is that there is no concept found anywhere in the Companies Act 2006 of a non-executive director. One of the concerns of advisors very often, and this is worth bearing in mind if you're advising people who've walked through the door, is that if they have pulled the strings in relation to a company, even without being seen publicly to have done so, they may be subsequently challenged for having been shadow directors and therefore having been responsible for something the company has done. It's fair to say that there are four key thoughts which came out of the Higgs report, which I think should be regarded as being the focus of what the non-executive's role is. The first is strategy. The non-executive is there to assist in the strategy of the company, not necessarily the day-to-day management, though there may be circumstances where he or she should be involved in that. This isn't a situation where the non-executive director should throw up his hands or her hands and say, well, on that basis, what's in it for me? I'm getting paid far less than everybody else, but I've got all these same responsibilities. Well, the short answer is you've got to look precisely at what the duties the non-executive director has taken on are. You've got to look at the relevant statutory provisions, the particular wording of them, and then you've got to see what the facts of any particular case are to work out what liability the non-executive director is or is not exposed to. The court will take into account what would be known or ascertained by a reasonably diligent person having both A, the general knowledge, skill and experience that may reasonably be expected of a person carrying out the same functions, and B, and this is perhaps most important for the non-executive director, the general knowledge, skill and experience that that director has. A case called Continental Assurance a number of years ago, where there was a director who came from a bank as a non-executive director, he came from a financial background, and when the company went into insolvent liquidation, he was pursued by the Secretary of State to be disqualified as a director. His defence in part was, well, I just didn't pay attention to certain of the things that were going on. The judge, Mr. Justice Chadwick, said, well, if he didn't pay attention, and I accept his word on that, he ought to have done, certainly as a corporate financier, and he was disqualified. If that good practice is followed, at the very least, the director faced with an unforeseen situation has a series of guidelines which he can go back to inform what his decision-making process is going forward, and should give him or her the confidence to say, I'm going to challenge that decision.